we have covered our overview of our goals and benchmarks for kids to achieve education success. We've talked about school stability and continuity, a big part of our goals 1 and 2. And now what I wanted to move to is special education, not a topic we're going to cover in completion. We have probably several educators in the room that I'm going to turn to. And, questions get too complicated for me, but I'm going to give you a little bit of understanding of what IDEA is. How about child welfare folks? Have we heard of IDEA? How many of you do know? Anybody here admit, I don't know what you're talking about? How about an IEP? Anybody here not heard of an IEP? All right, so we've heard of these things. We're not exactly sure where some of these services and basics come from. Okay. So special education, IDEA, Individuals with Disabilities Education Act. It's been in place under various names since 1970s, not earlier, 70s I think. And basically what it provides is a free and appropriate public education in the least restrictive environment for all children who are determined to be eligible. And who is eligible under IDEA are children who have specific disabilities that are determined that impact their ability to make educational progress. So there's several components that come in there, very similar to a lot of the, there's an evaluation piece to special education where children need to be evaluated to determine where their academic achievements are, behavioral issues, and really then a team is required, typically known as an IEP team, that will come together to really meet and discuss whether or not the child's issues that are determined from their evaluations warrant them to be identified with a disability and therefore meet and then identify services to meet those needs. The plan that's developed once a child is become eligible for special education services is known as an IEP. It's an individualized education program that's unique for the child. The purpose of that plan is to identify goals and benchmarks specific to those child's needs that are able to, that the plan will ensure that the child is going to make educational progress. So first, what's decided is what the child needs, what services need to be in place, and then what other kind of additional supports are needed in order to pursue that. There is something called child find that we all have to be aware of, and a part of IDEA puts a responsibility on school districts to, when they suspect a child might have a disability impacting, that they have an ability, a role in helping to identify which children might need special education services and refer them to the process for an evaluation. That duty, that child found duty, is specific. There is specific language in IDEA, new in the reauthorization in 2005, that talks to our highly mobile populations, our homeless youth, and our children in foster care, specifically saying that they have to have an added specific duty to identify those youth. But as many of us in child welfare system know, often it has to be those advocates who know the child to make those referrals to, and to point out to schools who may not have had, as we talked about, because of mobility issues, because of school, the child might have moved 3 times and no school had had enough contact with that student to have identified that they had some disability issues. And sometimes when families come into care, there's been mobility leading into them coming into care. Sometimes the abuse and neglect history that stems the entry into care that might be exacerbating those issues as well. And so basically the process, and this is a very oversimplified process, there's a referral. Somebody refers a child, whether it's from the school themselves, whether it's an external advocate, a parent, somebody says, we believe this child has a disability and needs to be, and we want to start the process. Typically, to make that referral, what I say is that anybody can refer a child, anyone. The court can order a party to the case to refer that child to start the process. The issue becomes, maybe that gets the process started. Maybe everybody sits down in a room to start the conversation of, okay, we're here because this child has needs, I think we need to do some further evaluation to determine specifically what the needs are. We need parental consent to start that process. And right there is where this big question of who is the person to sign that consent and to get that process started. Once you're over that hurdle, then evaluation takes place. The team meets to go over evaluations. The person in the parent role has a right to pending evaluations if there's any issues with the evaluations that have taken place. And then there's a determination of does the child have a disability? If they do, what services need to be in place in order to address that disability? And then, and only then, should the conversation be where is the right setting for this child to be to have these services. Least restrictive environment is a very important terminology in special ed land, and it really talks to the child should be educated to the most extent possible with their non-disabled peers. And so children should not be taken out of the classroom unless it's absolutely necessary. So can services be provided to keep the child in the classroom? And then if those can they be provided within the same school building? And only when that's not feasible to meet their needs should they be removed to sort of a separate school and a separate program. So that's what this restricted environment is. That's the extent of everything else I'm going to talk about IDEA, because we really need to address this issue of who is the parent. We need to address it because, one, you can't even start the process to consent for evaluation without it. Then, once an evaluation happens and there's a determination of what the needs are, a parent has to sign off on the IEP. They have to say, yes, you can put these services in place for my child. If we don't know who that is, or if we don't have the right person signing that, really, that document, which I'm a lawyer, but it's a contract. It's a contract between a school and a parent. And if the wrong person signed that contract, it's not a valid contract. And so this is very important to make sure who the right person is. Okay, so we have who is that person for child care. Can a child be evaluated before a decision maker is appointed? This is an interesting question that for the first time with reauthorization in 2005, we have a little bit of an answer. And what happens when a child changes living places? Okay, school can't provide the initial special ed services without consent of the parent. All right. Under the law that passed several years ago, there was a new provision talked about consent for initial evaluation. And it's a really important change when it comes to our kids. And basically this is what it says. School district may conduct an initial evaluation without parental consent under certain circumstances. The school district can't locate the parent. The birth parent's rights are terminated. I'm sorry, that should, yeah, under state law. Or a judge has removed the birth parent's educational rights temporarily or permanently, and consent is given by an individual the judge appoints. What is this? Where's this coming from? This came, I think, from lead into the reauthorization of IDA in 2005, when people were saying, for kids who are wards of the state and are in custody, we can't even start this rather lengthy process because nobody knows who can sign as the parent. This whole issue is delaying the beginning of this process to start. And so this, I think, was federal law's attempt to say, okay, for initial evaluation only, we are going to allow a few things to happen. And I think probably most significantly is the piece that a judge can tap somebody and say, listen, I don't know I don't know where this parent right issue is going to play out, but this person, I'm going to authorize them to consent to get this process started, and then we'll figure it out. That person isn't necessarily the surrogate. It could be. This really is something sort of separate and apart from the whole surrogate appointment process. But it could be. It could be at that very early stage, somebody decides, fine, let's appoint the surrogate very quickly and get that person to consent to the initial evaluation, and that's going to be the decision maker throughout the length of this child's stay. Another issue that I think this language was designed and why it doesn't say surrogate Because a lot of states say, oh, in our state, you have to attend the official surrogate parent training program. We only hold those twice a year or every other month, right? And so there was this other delay, or it takes 2 weeks, or something. And so there was this added delay of getting the person appointed and appropriated that was going to add to the timeline. And I think this is to say, no. We can have somebody quickly appointed. You just go forward and go ahead and start the initial evaluation. Appoint your surrogate during that time. Figure that part out during that time, and let's not add to this time clock. Everybody following me so far? No. Okay. Thank you for your honesty. Tell me, ask me a question.
So you're saying that parent rights are terminated, so an evaluation can be started?
No. I'm saying that when a child is a ward of the state, does Nebraska define ward of the state? All children in custody of child welfare are wards of the state? For kids in state custody, there is an exception in terms of starting an evaluation process under special education. Okay, clearly, if we know that the birth parent retains rights, they should be the one consenting to have that initial evaluation started. If there is confusion, if there is birth parents are nowhere to be found, we don't know who can appoint. Judge says, I can appoint a surrogate, but I don't have anybody to appoint because our courts don't maintain surrogate pools. And the school says, we can appoint somebody, but there's going to be a little process. We've got to get them identified and trained. Then this is a way that, that judges can limit and say, okay, birth parents don't have that right anymore. I'm going to tap, and this is probably the one exception to my absolute conclusive mandate that child welfare caseworkers cannot be the decision maker. This could be, anybody could. I probably would say, I don't think it's a great idea to have the caseworker do this just because I think it starts confusing things, but the judge could say, you CASA, go start the timeline. Start the process of the initial evaluation. Sign this document so initial evaluations can start. It's a way to jumpstart that process.
So, I'm confused as a school counselor. If we want to start looking at how we've been working with the teachers and educators for months and months. We get to this point, or what is it? Do we contact the caseworker? Do we contact them, especially if we're going to be terminating temporary?
Right. From a school perspective, how does this play out? So how would you typically invite a child's family or identified legal guardian, custodian? Who do you think you would typically invite for a child in care in the same way that you would do a child who's living with a birth parent?
Well,
is that clear to you?
No, right?
Yeah.
Not really. That's
from the school standpoint, there's so many different people involved, and I don't have a background in foster care, so I never know who's what, who's meeting to, and then getting the signature of the text. How do you know which person is to that?
Right.
And that's a modern process in itself, and then we're talking about there being judges, and that just seems, I mean, I didn't know how to do that. Is that the school's responsibility to start with the judge? Is that the responsibility?
Yeah, I mean, I think what you want to do is if you've identified, hey, there's an issue. There's no parent, there's nobody else who seems to stand in the shoes of the parent to make this decision, and we need to get this evaluation started. I think the appropriate thing would be to talk to anybody who's a party to the case who has access to the court. So even though schools don't necessarily have direct access to the court, and I'll have the judge correct me if I'm wrong on this, but I would say, hey, caseworker, you've got to tell somebody's got to get a court approval to get this moving. Let me move on. We can come back to this. Let's talk a little bit about the parent definition under IDEA. Maybe this is a better place to start, okay? How is parent defined under federal education law? This is how it's defined. Birth or adoptive parent. Everybody's with us, all right? Foster parent, unless prohibited by state law. Any law in Nebraska that prohibits foster parents from standing issue with the parent. Foster parent should be due to the parent from the school's perspective under IDEA. Guardian, generally authorized to act as the child's parent or to make educational decisions for the child, but not the state. If a child's a ward of the state, no caseworkers. Caseworkers can't be the parent. It could be somebody appointed to make, it could be a guardian, an educational guardian that the judge appoints to make education decisions under that one. Person acting in the place of a parent with whom the child is living can be a non-relative. A person legally responsible for the child.
Does that person have their state?
What's that?
Person legally responsible for the child, doesn't that come back to the state?
No. Actually, that shouldn't be a separate bullet, actually. A person who's acting in the place of the parent with whom the child is living can be a non-relative who is legally responsible for the child. There's actually an error on that slide. That should be all combined. But no, it can never really be the caseworker. It's very clear in the law and rights on that. Okay, so that's a lot of people who meet the definition of parent. Right? Go ahead.
I have a question. What is the difference between a surrogate parent, an acting parent, and a legal guardian of a child?
Great questions. Hold on to it. If in 10 minutes I haven't answered it, I will. Okay? We're going to talk about surrogate parent in a minute. I think my point here in that definition is that there's a lot of different people who could potentially meet the definition of parent. At the break, we were talking about this a little bit with some of the school folks who are here. And I said, it is my wish and desire that all the technical assistance calls I get from around the country are because of IEP meetings for kids in foster care where 20 people have shown up and the school doesn't know which of the 5 people who might meet that definition should sign for the child. I hope that's what our biggest issues are. That's not what's happening. But there is a reality there that, hey, what if more than one of these people is there? What do I do? And so in 2005, there was an attempt to address that, and here's what it said. When the birth or adoptive parent is attempting to act as the parent, the birth or adoptive parent will be presumed to be the parent unless the court has decided that the parent doesn't have legal authority to make education decisions for the child. This is straight out of the federal IDEA. What does that mean? Birth mom and dad trump. Adoptive mom and dad trump. But court trumps all. Right? If it's birth mom and foster parent at the table, unless you have a court order that says no, birth mom can't do it, it's birth mom. Right? So birth parent trumps if they are attempting to act. What do you think that was? What's attempting to act mean? Does attempting to act mean we've got some special educators here, right? We've sent 2 certified letters and made 4 phone calls that were all documented in the file, and no response throughout that period of time, and right? They don't show, despite our best efforts to notify them. Maybe birth mom's not attempting to act, right? We've had communication with birth dad, and he said he was on his way, and he was, we've had good communication, he was coming, and at the last minute we got a call right before the meeting was supposed to start that the bus broke down and he isn't able to get there. Is he not attempting to act? I don't know. So I think there is a piece here of what parental rights and parental authority. IDA is about, we like to think of it as a law that's about kids. It is about kids, but the rights flow to the parent. So why it is so complicated for kids in foster care is we don't seem to have a complete handle on who is the parent when they're in this situation. Okay, so if the birth or adoptive parent is not attempting to act, the education agency can treat one of the other people on the list as the IDA parent. However, the digital decree or order specifies another person, either as a surrogate or as the guardian, okay? Education agency must accept that person as the IDA parent. So again, birth parent, adoptive parent, they're present, they trump. If the court decides otherwise, they trump all. What is a surrogate was the question, right? So we have, remind me of your question. What were the terminologies that you, acting parent?
Parent, surrogate parent, and legal guardian.
Okay, so acting parent, I guess, really goes to that definition, right? Who are the people who can act as the parent?
And that's something the school district would then appoint if that biological parent cannot be found.
Well, how this plays out, it's not appointing anybody. It's who they can view to stand in the shoes. And so based on that definition, right, it's if one of those people who are there, who meets that parent definition, they can treat that person as the parent. Okay? They're not really appointing anybody.
But then, so our district would then appoint, Brad, correct me if I'm wrong, you guys would appoint a foster parent as an acting parent, or do we automatically assume a foster parent is an acting parent if we can't get a hold of the biological parent?
We would document if the parent is not available or not involved, or the rights are terminated.
Right.
We would document the assignment of that surrogate parent, foster parent might be a possibility, or wherever is acting on behalf acting as a parent. That's typically
Okay.
the case. We would identify them as the surrogate parent with responsibility to send.
Let me tell you that one of the things that the change in 2005, I'm not sure every state has necessarily changed, we didn't used to have foster parents specifically listed out as a party that met the definition, parent. So in a lot of ways, the only way that foster parents would serve in that role was through a surrogate parent. And I had a lot of debate before the 2005, when I was still talking about this, and it was still confusing then, which was, does a foster parent have to be appointed as a surrogate, or can they just act? When this passed, I think it made clear that some foster parents would be viewed as the parent without having to appoint a surrogate. I don't think it's bad to have foster parents go through the surrogate parent appointment process. In fact, there's a training component, there's a support component built into surrogate parents, so I think that's okay. I think just it's important to note, though, that there was this change in the federal law that they don't have to necessarily, unless there's something in your state law where you're mandating that your foster parents have to go through that appointment. So there's two things. So in one place in the regulations, it talks about who is the parent. And in another place, it talks about the surrogate parent. So what is a surrogate? And so this is what the law says. Education agency must determine whether a surrogate parent is needed and should assign one within 30 days. If no IDA parent can be identified, if the child is a ward of the state under the laws of the state, or the student is an unaccompanied homeless youth under the McKinney Benton. When do you in Nebraska determine that a surrogate parent is necessary? It sounds like even if there is a foster parent, you might appoint them as a surrogate? No.
Not a parent's rights. We get a notice from the superintendent of the parent, whether the parent's right to be in effect. Unless that notice tells us otherwise, you always go back to the applicant.
That's right. So first and foremost, it's the natural birth. Let's say, no termination of parental rights yet, but natural parents are MIA. Haven't been part of the child welfare system. There's a TPR scheduled a few months from now. There's no birth parent. What do we do? As a school system, who do we look to? When, I guess my question is, when do you as a school think about surrogate appointments? Anytime there isn't a birth parent available? Yeah?
It usually doesn't come up until there's a situation where a parent's signature is needed. So we wouldn't
Right.
just do it in the course of serving the student.
Okay.
But when they have that, the testing or the IP, then that's when it comes up. So like you said, you document effort to try that. And then you determine that you have a surrogate. I would say in that situation, she gave the example where the father was attempting to come.
Mhm.
Gus wasn't available.
Right.
That shows some response and some interest in
Very important with incarcerated parents. Very important with incarcerated parents. Often we hear, nope, they're incarcerated, they give part of it. Absolutely. Accommodations can be made to include incarcerated parents. And should be, if they still want decision making. Okay, so the real issue that we're trying to get to here is how do these two pieces interplay? And I think it's an excellent question. Is what is the difference between a surrogate parent and a person acting as a parent? And it's going to vary by state. And why I was asking a little bit is where do these two things come into play? Surrogate parent here is listed as somebody who can be considered the parents. But when do you need one? And typically, as I see it, most states say, when there's nobody else on the list. Right? So how about a child who's in a group home, congregate care setting, RTC, very involved special education issues? There's no foster parent. There's no person they're living with. Their birth or adopted parent is nowhere to be seen. That's going to be somebody where there is no one who meets this definition, and we need to appoint somebody. And that's typically where we see surrogate appointments happening. I point out that in some states there's sort of this added level, well, they'll still appoint some of these people on this list as a surrogate. And I think there's pros and cons to that, including if it's causing delay, and really you can analyze the law and how it interplays with your state law, and those people could just automatically be viewed in that role. We don't want to cause any more delays. We also have to remember, I think it's, people have a very mixed reaction to this. Foster parents are automatically the parent under IDA. For a foster parent who understands IDA and does a good job advocating, that's wonderful. And for foster, there's some don't tell people in my state that. Some of our foster parents don't want that role, can't handle that role, it's not appropriate for them to have that role. And I just think it's important to know that that is the direction the federal law took. And so if you have foster parents who are wonderful care providers, but aren't going to be good education decision makers, the court has to make that clear that they're not to serve in that role. Because remember, court trumps all. So it needs to spell out that the foster parent shouldn't be the person to make that role, to do that. And hopefully then you've got somebody, but the critical point is if you're saying foster mom or foster dad can't, we sure better have somebody who can. Right? We need to have, and if there's nobody within the case who can, it's where the sort of the surrogate piece comes in. What else does the law say about who can be surrogates? Can't be employees of state or local education agencies or other agencies involved in the education and care of the child. They can't have conflicts of interest, and they must have the knowledge and skill necessary to be good surrogates. Oh, did I also mention that in the 2005 reauthorization, there was a new provision in the alternative. Juvenile court judges can now appoint surrogate parents in addition to the school. So that's another question I get. Well, that's confusing. What if the school's appointed a surrogate and the judge is appointed a surrogate? I don't see that happening. More often, I see nobody's appointed a surrogate because the school doesn't have anybody to appoint, and the judges didn't even know that they had the authority to do it. Okay, and I think, so some of this law is meant so that nobody slips through the cracks. We have multiple avenues and ways to get here, and it's just piecing it together. And believe me, I didn't write this, and it's confusing. And I think they tried in 2005 to make it less confusing. In my personal view, they actually complicated it a whole lot more. But there are some things that are positive. So surrogate parents appointed by judges, interestingly enough, have a little bit less criterion around it, right? Can't be employees of the SCA or LEA. It still can't be, a teacher at the school. It can't be caseworkers or other agencies involved in education and care of the child. And that's it. And I think there's a sense there that the judge is someone who is not going to appoint somebody who has a conflict, and part of their job is to make sure the person they're appointing has the knowledge.
So guardians ad litem could be.
Well, that's interesting. We were talking about that at the break. I mean, yes, in theory, guardian ad litem, in theory, a cost that can. I think my only warning about guardian ad litem is we have to really think about what their ethical responsibilities and their standard of representation is related to their client. And when you're a surrogate parent, it's far more of you are doing a best interest. You're acting as a parent. So if there is a conflict there, I think you success I've heard of having classes. But again, I think the key is, whoever you're appointing, have they had additional training and opportunity to have the kind of expertise involved in what it means to be a surrogate parent and to understand how the process works. You know, a lot, we talked about it at the break, a lot of times when you hear, I've been to states where, I've been, judge, come up to me, I've been doing this with your surrogate parent, I've never heard of it. Never heard of it. Schools don't maintain them, they don't exist, nobody's ever asked for one. So if you don't ask for it, why maintain a pool of people who none of the advocates are seeking? A lot of times they're retired administrators, teachers, people from the school that the school maintains as volunteers who understand a lot about special education, very critical. But the piece that I think is also equally critical is you have to understand CASA and kids in care. And so it's sometimes a challenge to find a pool of people who understand both. And so CASA may be a great option. Go ahead, Vicki.
What about a relative who might not be able to be home to the child? And, they may not have all that expertise, but they may be not unsimilar to a parent who's involved.
Right, and I'll tell you, that is the very reason, and Vicki just said a relative. What about a relative in the case? It's the very reason why I was very happy with the addition of judges. I don't know if it's all school folks, but judges are also appointing surrogates, and that is because I think judges who are overseeing the case, they know who shows up in that court hearing to hearing. They know more about who the resources are for that child than necessarily the school will. And so I think a court can sometimes know who that individual is, who's going to be looking out for that child. The aunt who's got 2 special needs children of her own, who wasn't able to open up her home to take her nephew into her home. But oh, by the way, did I mention the 2 special ed kids who are getting fabulous services and really been to more IEP meetings than anybody in this room, could be a phenomenal advocate for the child and could be appointed very easily by the court. No reason that aunt couldn't be appointed by the school too. It's just somebody would have to go to the school and say, hey, here's somebody who would be a great person to appoint. Right? Nothing would stand in the way from the school appointing a surrogate known to the child, right? Yeah, but they still would have to go through certain requirements to the school that they might not have to go through if they're appointed by the court. Unaccompanied homeless youth, we just throw this in here to note that they, under McKinney-Vento, there is part of eligibility under McKinney is this category of kids unaccompanied homeless youth. I do say that if a child, do we have kids who run from care? Teenager, bust out of a placement, right? That child is McKinney eligible. That kid on the run. And would really, in many ways, meet the definition of an unaccompanied homeless youth, even if they're in the custody. This also covers kids who aren't in the custody. This is unaccompanied homeless youth. Typically, they aren't in the custody, but also kids who are in custody. A little bit of an oddity for unaccompanied homeless youth is this concept of temporary surrogate. And this is somewhere where, for unaccompanied homeless youth, the following people can be temporary staff from emergency shelters, transition shelters, independent living programs, street outreach programs, state or local education agency or agency staff. So this is in complete conflict with everything I've told you about school staff, somebody with care and education responsibility. Why is this there? Because I think for kids who typically don't have court access, so an unaccompanied homeless child who's not part of the child welfare system, there's nowhere else to go. And I think the issue for true unaccompanied homeless youth who aren't court involved is that unless you allow one of these people immediately involved, there's nobody else to look to. And so it's temporary, it's not the permanent person, it's to quickly, it's the homeless youth version of that initial evaluation jump over. Does that make sense? In the room? My good folks who admit when I'm losing them? Does that make sense? A little bit? Sure. I'm not convinced. Yeah.
Maybe we're unique. Most of our unaccompanied homeless youth, most of our relatives, the parents are still here. They just get it up to the parents are kicked out.
Okay.
Is the birth parent still the person responsible?
If they're there and can be, yeah. Yeah, no, I didn't mean to. My thinking of unaccompanied homeless youth is for the youth who really is on their own versus the parent. Good point. Thank you. So let's get back to this judge piece, because I talked about judges a couple of different times in this. So let's just go over. A judge can appoint an IDA decision maker to make special decisions for a child whenever and whatever extent such a decision is permitted by state law. Really, when we talk about judges being able to appoint surrogates, there is a limitation in IDA because it says judges can appoint surrogates when a child is a ward of the state, is an IDA ward of the state. Okay? And what IDA did is it defined ward of the state as all kids in the custody of child welfare agency, except for kids who are with foster parents. So it's confusing. Why on earth did they do that? Well, I think they did it because they added foster parent to the definition of parent. Okay? So judges, I said judges can appoint surrogates in the alternative of schools. There is a limitation to that only when it's a child who's not with a foster parent. Strange, right? But the way we get out of a conundrum of, wait a minute, but what if that's not who we want, is that judges also can appoint, off of that parent definition list, a guardian at any time to trump. A judge can appoint, forget surrogate process, a judge can appoint somebody to make legal ed decisions at any time. Can trump the parent, can trump the birth parent, can trump the foster parent, can trump anyone. So courts can do it in two different ways, through a surrogate appointment, through a guardian appointment. That's the important thing to know there. Raise your hand if there's anybody in the room who isn't lost. Okay, so I've trained on this for a long time, and it's tough stuff. It's tough stuff. I think, let's think about, let's stop, turn the brains off of trying to, figure out everything I just said, and know this. Every child who's in foster care, at every point during their age, we need to know who's making decisions. And so some of this, there's some very nuanced stuff about your state law and how it applies. This is a really important area that I think courts and Department of Education and your Children's Division have to come together and talk about how this is really going to play out. And work out some of these legal requirements to make sure there's a way to ensure that there is somebody making legal ed decisions and that there's a way to make sure that person is the best person to make the decision at every point in the process. Is that fair? Okay. There is a black Mazda with a license plate RCJ082 and your alarm. It's our video guy now on Instagram. Okay, so here's a couple other issues. So anybody want to ask questions about decision making, or you just want to let it sit for a minute? Go ahead.
Well, it's the hypothetical situation that keeps bouncing around the contemplation process and complex psychological needs and there's never going to be a fit. I would think it would be best for the child best interest to have the same person making educational decisions each time, not foster. What you're saying is
And I think, what used to be in the law that they took away could still be embedded somewhere in your state law or regs, but it doesn't exist in federal law. Is sort of foster parents can act as the parents under certain circumstances, and one of them was a long-term relationship with the child. They took the language away. I think in some ways they wanted to free up the ability to have foster parents act as the parent in certain circumstances and not have there be confusion about that. But there was some sense to it because you don't want it to automatically be the foster parent jumping around. But there are ways, just because the law says that, it doesn't mean that there still is what is best for this child, who's the right person to make the decisions. Still has to be paramount. Yes, ma'am?
In terms of the failure to follow through on evaluations, with the 0 to 3 population, Nebraska does a great job, I believe, in making referrals as required under CAPTA, but the number of children that get services is far less than one would expect. So there's a real breakdown in terms of, I don't know how the referrals are made, and then children actually getting evaluated and getting services. So is this a potential solution to that?
It's not a solution, but it's an important component to that. So let me back up and make sure everybody understands what Vicki just said. So what we've been talking about is IDA, special education, and a majority of folks who think about IDA think about Part B of IDA that covers children from the ages of 3 all the way through 20. Okay, there is another part to IDA that's Part C that addresses children from birth to age 3. And one of the real strengths in IDA, reauthorization, as well as a requirement in CAPTA in both, which Child Abuse Prevention Treatment Act and Federal Child Welfare Law, in both places, around 2004, 2005, there was language that said all children who have a substantiated finding of abuse or neglect, so we're not even just talking about cases that come before the court, but all substantiated abuse or neglect cases must be sent for a referral to determine whether or not they need Part C services. And Part C is very similar to Part B, but it's specifically for our infants and toddlers to determine if there is any kind, if they are at risk for, if there is a developmental delay, a high probability of developmental delays. At risk, part of your Part C here? Okay, so developmental delay or high probability of developmental delay. So all kids who have substantiated abuse or neglect findings between birth and 3 are sent for some kind of a screening evaluation to make that determination. So what Vicki is saying is, while they're all sent and that process is compliant with the law, a very small percentage of those kids are actually been identified to qualify for Part C services. And you think that's a little, you have some concerns about that, and I can see why. Because when you think about developmental delay or high probability of developmental delay, a history of abuse or neglect, if there's substantiation, the one thing you know is that the child has been abused or neglected, really raises the likelihood that that child could have a developmental delay as a result of that abuse. So what's the result? I mean, this who is the parent applies to Part C just like it does to Part B. And if it was clearly identified who the parent was in that process, and if that parent said, hey, they didn't qualify us for services, I disagree with that, there's sort of a whole process, a dispute process, including not just a request for mediation, a request for due process to really review, was that effectively addressed?
I think, I also think that the bio parent, where the child is not living, is often the one that is invited to agree.
Right.
And they're declining. They're declining to agree. I thought.
Yes. Okay, great. So, important part of Part C services is there can be an evaluation of Part C. The evaluators say this child is eligible to receive early intervention services that are going to help work with the child who's been identified with a concrete delay. And you're saying, birth mom or dad are saying, thanks, but no thanks. Absolutely permitted under law. Schools and Part C agencies can't force infant and toddler services on a family. But if that family is in the court's jurisdiction, and there are parties to the case who say, hey, wait a minute, this parent who we're giving education decision-making authority just made a really, really bad decision for that child, everything we talk about comes into play. Because that's exactly where a judge can say, somebody's got to raise this before. Somebody's got to say, hey, this child was determined to need services, the parent refused them. It's definitely to this child's detriment. Why is this, so either it gets raised in court and maybe some court pressure on the parent and maybe it's that the parent needs somebody who doesn't understand what just happened. This isn't about parents being malicious. It's not understanding. There's a whole system right now that's just taken their child or is threatening to take their child and, services that maybe they're a little suspicious. And so how do we work with parents to say, hey, these are services that can really help you and help your child? And there's wonderful models out there for Part C services where Part C programs come in. Let's say that the baby or the infant, the toddler is in a foster home where they use the foster parent and bring in the birth parent and sort of model, I mean, the difference between an IEP and an IFSP is that an IEP is an individualized education program. IFSP is individualized family service program. So when you're talking about little ones, we're talking about what techniques do you improve in terms of how the parents engage the child and help overcome whatever disability. So you can really use foster parents and birth parents and sort of model good parenting and model ways to address those kind of delays and disabilities. There's a whole bunch of things right there. Yeah.
Just let me ask you a question. Number one is parental denial. The second thing that's happening is they're supposed to complete the evaluations in person, and they're doing them over the phone. Does this child appear to be developmentally on target? Yes, it does. Okay, we'll close it. If you have any problems, call us. And by law, they're supposed to be doing those in person, but they're not.
So these are the screen, you're saying is a really abbreviated screen. It's not a full-on evaluation unless somebody asks for the full-on.
Correct. I mean, they don't even see the child in person. As I said, it's strictly via the telephone.
Yeah. Yeah. Who's doing?
That's not statewide, there are certain places that do that. At the state level, we provide guidance that says that the guidance from the state is saying that you have to conduct some screening that involves working directly with the child and the parent. In some school districts, because they've got some major girls, are trying to screen them first. Obviously, a parent is not going to be, especially if it's not very likely to say, oh yes, we have problems in our municipality.
Right. So it sounds like number one is that Part C is through Department of Education here.
Yes.
And number two is there are regulations coming forward to help districts sort of understand more clearly the extent that those evaluations have to be
Part C,
implemented.
Nebraska is unusual that Part C is, they're totally agencies, and it's the Department of Health and hope that we're able to do.
Okay, Department of Ed, and they just, it's not always Department of Ed in a state that oversees 0 to 3. Sometimes the count is the state health agency or, a whole bunch of other options. Okay. Anything else? Where am I on my? I think I'm blowing some of my time issues here, but let's just really quickly, because we talked a lot about mobility, there's a couple of areas I wanted to hit on that I think are really important when it comes to kids in foster care and special education. Here's one of them. What if a child moves after an IEP is written and signed? Okay, so when a child is moved within the state, new district must provide services comparable to those described in the previous held IEP and ensure FAPE, free and appropriate public education, until district formally adopts the old IEP or negotiates a new IEP with the parent. So what we hear a lot from kids in care is, the child's being enrolled in the new school says, oh, we can't enroll them until we have a new IEP. Can't do that. They can expedite a new IEP, but they really are legally required to implement the old IEP. And if they're really concerned that the old IEP is cutting it, that's the impetus to get that new IEP developed as quickly as possible. Okay, and transfers from another state, it's really the same goal. Comparable services until the district conducts the new evaluation, negotiates a new IEP. Sending and receiving LEAs must make sure that the assessments of children who change districts during the school year are coordinated as quickly as possible to ensure prompt completion of full evaluation. Evaluation timelines, okay, so when you have this meeting, hearing consent, evaluations must be completed within the 60 calendar days, or unless your state has an alternate deadline. Did your state have an alternate deadline? 60 days? 45 school days, great. Has to be completed. Here's another one we hear a lot, right? The process starts. School A does nothing. Doesn't start it. We sometimes hear that school A is crossing their fingers and says, I'm going to gamble at 45 days this child's not going to be here anymore. It will be our problem. So on day 44, the child does move and is re-enrolled in school B. How many days do you think school B has to complete an evaluation for that child. Possible, but the law. So was this trying to address? It's saying that the timeline doesn't restart each time you move, or it defeats the purpose of effectively speeding up the process. What's the only exception? Unless the new district is making sufficient progress to ensure prompt completion of the district and the IDA parents agree to a specific time for completion. Again, the school can say, who's the legal decision maker here? Help us out. This happened. They started it. They didn't do a good job. And we agree to some other timeline. But again, another important parental ID. Who's the IDA parent? That's the person can agree or disagree to allow some alternate timeline. Okay. We're not going to have discussion questions. We're going to move on to a very quick overview of information sharing. And then I really wanted us to have a little bit of time to take a look at that case scenario that I handed you. So what do we think about this issue of sharing records? Somebody had called, a colleague of mine who was doing a session decided to title it, I'll show you yours if you show me mine. I said that wrong. Show me yours and I'll show you mine. Right? Is that really what this issue is between child welfare and education? So, some of the attorneys in the room, we get education records from our districts. Is it clear cut? Not a problem? We're getting them? Yeah? Schools? You think education records are being released to child welfare agency folks pretty routinely? To a caseworker, to an attorney? Any issues with that we hear about?
I think if we know that we're supposed to get it.
Are you?
We just send it, sometimes we want to know from different agencies.
Right. And what do you need? What is it that you do need to be clear that you would send it? So, and then how about all you folks in child welfare when the school says, well, could you show us some of those records from your file? Because we're trying to educate the child, and we need to know what happened in the foster care case to be able to make sure we're addressing everything. What do your workers and attorneys do when the education agencies want you to do that? Right? Some legitimate, some not. Right? It's not reciprocal. I think when child welfare has custody, okay, and if certain confidentiality hurdles are overcome, education agencies should need to be sharing those educational records of the child with the custodial agency, with the foster, these are people who have day-to-day contact, are the legally responsible, they gotta see it. Do education agencies get to peruse through the child welfare file and see all the details about the abuse and neglect in the home? And, but they are educating the child. They do need to know basic facts that don't set these kids up for issues. The example I like to give is, you've got a, horrific case of a child who the abuse went on for, months, if not years. The child was locked in a closet, deprived of food, very horrible conditions, right? Case is full of details about, families perhaps mental health issues, condition, physical abuse, sexual abuse that went on with the child during this horrible period. Does the school need all that? No. Does the school need to know Johnny has had a history of abuse or neglect? Using the time-out room, that's a small enclosed space, as a disciplinary possibility for this child is unacceptable for John, right? I mean, it's those kinds of things where, when we don't share that information, and the school does discipline Johnny and puts him in a very enclosed timeout room, Johnny has an absolute outburst, and the next teacher, administrator, who walks in the door, Johnny knocks out, physical, and so the next thing you know, we've got a long-term extension with a request for expulsion of Johnny, when all of that could have been avoided with some consciousness for privacy, but knowledge of what everybody's trying to do, right? Everybody knows what I'm talking about. So, why do we have this issue where people don't know what they can share and what they can't share? It's all because of the lawyers, right? It's all because there are strict confidentiality laws on both sides. This, child's educational records and information, you can't just, advertise them in your local paper. You can't plaster that out in public. And why can't schools? It's because of this law, the Family Educational Rights Privacy Act. Federal law that basically is there to protect privacy interests of parents and students regarding their information. So this section we wrote up sort of like this. So we can't share, education myth number one, we can't share any information about a student with anyone who is not considered the parent. And we hear that a lot because schools are just used to dealing with parents. A lot of schools have never had a situation where a child is not living with a parent, and that is what they're used to. But the truth is that, number one, you've got to be clear on what an educational record is. Not everything is considered an educational record. Some information is what's known as directory information, and while parents do have an option to not disclose that, there's sort of a different level of privacy over those issues. And then the second part is we can't share child-specific educational records with anyone without parental consent. The only individual with automatic access is a parent and children over the age of 18, okay? But just because, they should be able to gain access, and here's how. Okay, number one, and all child welfare folks should know this, the very first way for anybody else in the child welfare system to gain access to educational records is to have parental consent. And I think a lot of times when kids come into care, come into custody, parents sign consents to release that information to various folks, and we're good. For the attorneys, often in your court order of appointment, do you have included in that court order of appointment the court? The court specifically allows you to gain access. And so from the school's perspective, those two things alone, if you've got a parent consent or a court order, there's no issue. There's also, I think, at least an arguable position that based on the parent definition under FERPA, which is very different than the parent definition under IDA, that the child welfare agency and foster parent could be considered to have access to that information just like a parent. It's not under IDA, while those caseworkers are restricted, it's not the same definition. And the definition includes a natural parent, guardian, or an individual acting as a parent in the absence of a parent or guardian. So some could say the agency is the guardian. Certainly if the parent isn't available, then a foster parent or a caseworker could be considered. And then of course, always, 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 if there are issues, there are exceptions to needing parental consent, and a judicial order is one of them. And so whenever there is an issue, and it probably should just be part of the form judicial orders that you have, is to make clear who has authority to have those education records. And then your workers or your attorneys or your CASAs can go into the school, and the school knows, okay, if they have that order signed by the court, we can release that information. Everybody good with that? Okay. Unless we receive notice from the parent, we hold no responsibility in getting education records to a new school when a child transfers out of the school. FERPA specifically has nothing to do with parental consent. Old school needs to send records to new school. That's required, school-to-school record transfers. You don't need parental consent, you don't need court orders, you don't need anything. Schools have to do it. What's interesting now is under Fostering Connection, I think child welfare agencies have a clear responsibility to make sure it happens. And schools have to do it. So this part should be very, and it never is. There's always delays. And there's a lot of different ways we can go about this. But I think as records become more electronic, hopefully these are issues that go away. I remember, it wasn't in my Maryland suburban county where we had issues. Usually we were able to do it. We had a lot of kids that were placed in the district who were coming from schools in the District of Columbia. As a child's attorney, I knew if the child needed records, I got in my car, I drove to that school. I remember standing at copiers making copies of those records because it was the only way to make sure that they transferred. It's not what the law says, but it's a reality of we have to make sure these kids have their records that are valid. I'm going to speed through some of this. Oh, child welfare myth. We're not obligated to keep education information in our child welfare case files. Absolutely false. Part of child welfare law, this isn't new with Fostering Connections. This has been in place for a long time. Child welfare agencies have to maintain educational records in their case file. It's a requirement. Name and address of health and education provider, grade level performance, school records, any other relevant health and education information. Records must be reviewed and updated. And then these two were in the past several years, addition. Caseworkers must supply a copy of those records to the caretaker. So there is an agency responsibility to give a copy of those records to the foster parent or the caretaker. And they have to supply them to you for their instant care. There's nothing more frustrating when you talk to these young people who have struggled in school, who have, fought to stay on track, and they learn, what they think is their last couple months of their senior year in high school, that by the way, in your 7 schools that you transferred to, we've lost the records. Nobody seems to be able to verify your sophomore year, and therefore you're X number of credits shy of graduating, and you can't graduate yet. It happens. And it's because we are not maintaining these records and we're not giving the kids the access to them. And also, somebody was pointing out at a recent forum we had for older youth, don't just hand these poor kids a stack of papers. Anybody here a parent of adolescents? I mean, that doesn't make a whole lot of sense. And so what are we doing to sort of preserve some of these, somewhere on an electronic database, something that has the privacy issues attached, so we can really make sure that these kids can have access to them, and it's not, a shopping bag that they're carting around as they are trying to figure out ways to make it as young adults independent. Okay, we've done a lot of work around information sharing. Here are a couple of resources. I think we're pretty short on time. Am I right on time that we've got about 20 minutes left? How do folks feel about taking about 5 minutes? And in your packets is a scenario that we wrote out, and just see if we can just have a little bit of time this afternoon as we wind up, sort of applying some of the issues that we've addressed today. I think that yeah, everybody just take about 5 minutes to read over the scenario, and then I'll check back in.